Hi everyone. So board exams, woohoo! Super exciting. Before I start, let me give you guys some motivation. I wrote my first two board exams when I was heavily pregnant with my first daughter, and I passed with all the pregnancy hormones and so on. And I wrote my second set of board exams when she was just a few months old. So if I can do it, you can do it. It's no big deal. And once it's over and you pass, it's done and dusted, and you don't have to think about these things again afterwards. Not really. You do need to think about it. That's kind of the point, right? Okay, so today I'm going to be discussing paper 3, which is ethics. Absolutely love this area. I'm not saying that because I'm having a little chat about it right now, but genuinely I love this area of law. I love lecturing it. So I've lectured this topic at university level as well. And the reason I love lecturing it and I love talking about ethics is because, in my opinion, ethics is the one thing you actually really are going to use in practice. I was speaking to a newly admitted attorney this morning. We were both in court, and obviously I've been in practice and I've been admitted for over 10 years now. The same little girl that I was pregnant with is 11 this year. So I was speaking to my colleague, and we were discussing board exams and university, and he said, nothing prepares you for practice. And I'm gonna agree on that. I feel like a lot of it doesn't prepare you for practice. However, and I cannot stress this point enough, ethics is real, and you need to know it, and you need to know it well. And having said that, when you're studying for ethics paper 3, please do not learn it in isolation, because ethics doesn't just fall under, you can't learn it in a bubble. You have to, because ethics falls across various aspects and various areas of practice, and so you need to know how to implement ethics in those various areas. So I'm going to get into it. Obviously, I'm not going to be able to go through every single aspect of ethics, but there's a few that I want to just emphasize on for the purposes of today. And we're going to talk. So let's just start off. What is ethics? What does this mean? So in order to be an attorney, you need to be, who's going to answer the question for me? You're going to have to prove to the court that you are fit and proper to act as an attorney. So not just any old buddy off the street can actually be considered as fit and proper. You need to actually have conduct that shows that you are fit and proper. One of them would mean that you wouldn't have a criminal record, and there's various other other aspects that we looked at when we talk about a fit and proper person. And why do we need someone who is fit and proper to practice as an attorney? That's because attorneys are required to act in a very ethical manner. So you're supposed to deal with all aspects of your professional life in an extremely ethical, good moral fiber. You're supposed to have good relationships with your colleagues. You're supposed to have good, open, moral relationships with the courts, with your clients. So it really does spread across every single aspect of your professional life. So ethics is something you need to know, not just on paper, not just to pass your board exams, but it's something that you need to know in practice. So what does it mean for an attorney to act ethically? All right. So first of all, just to get us into the whole aspect of ethics, I want to give you guys an example, because this is really what's going to happen in paper 3. They're not going to, they may say list, when would you find a conflict of interest, but more often than not in paper 3, they give you a scenario, and they say to you, this is what the client has come to you with. What is your ethical obligations here? So let me give you an example. Let's talk about prescription. So let's, for example, say a client approaches you and their debt has prescribed. By now, you know what's prescription. If you don't, you're going to fail. I'm just kidding, which probably will. So you need to know what's prescription. This is why I say you need to know all areas of law. So your client says to you, okay, the matter, gives you the file, and the matter has actually prescribed. What is your ethical obligations as an attorney to tell your client? All right, so number one, let's just dive straight into it. So number one, you can act. You can act in a matter where the merits may not be in your client's favor or may be unfavorable. You need to, your ethical duty though is to inform your client and say to your client, listen, this debt has prescribed. However, the obligation to raise the defense of prescription is on the defendant. Therefore, we can proceed. Your risks are that the court does find in favor of the defendant, and you could end up with a cost order against you because you proceeded on a file that was prescribed. So it's dangerous. On the other side of that, so the defendant has to raise it, and they have to raise it via a special plea. So there's a special format, a special way in which they raise this defense. It can't just be said. There's a proper procedure that needs to be followed. And if your opponent did not raise the issue of prescription, the court cannot raise the issue. So they can't be raised in what we call mera mutu. So the court can't raise it themselves. This is something that needs to be raised as a special plea by the defendant. And so that would be your moral obligation. That's it. That's what the ethics are. It doesn't necessarily mean you need to start now panicking. Oh my goodness, it's prescribed. You need to just inform your client. These are the risks involved. This is the possible outcomes. This is some of the strong points in that, for example, it has to be raised via a special plea. The judge can't raise it, or the magistrate can't raise it. They may see it as prescribed, but they're not allowed to raise it. And your job is done insofar as advising your client in an ethical manner. All right, so that's the one part, and that's just one example of how we deal with clients, all right, and being ethically sound towards our clients. Let's use another example. Let's say that we have a magistrate who is presiding over a matter, and you are aware that the magistrate either has a personal relationship with either the plaintiff or the defendant, or maybe even one of the witnesses. And this obviously then means that the magistrate should not be acting in the matter. That's improper. It would be improper for the magistrate to act in that particular matter. So what is your obligation ethically as a legal practitioner? What do you need to do in that situation? So there's actually a number of things. When you're dealing with the court, you kind of have to be very proper about the way you deal with it. You have to, of course, approach the magistrate. I would do this in chambers. I wouldn't stand up, although I've had colleagues stand up and just tell the magistrate, I think you need to recuse yourself. I would not do that. I think the proper thing to do is to approach the magistrate in chambers, bring this to magistrate's attention or the judge's attention and say, I believe that perhaps your worship has a conflict of interest in the matter, and that your worship should remove him or herself from the matter. If the magistrate or judge refuses to do so, then you can bring a formal application to have that particular presiding officer recused from the matter. If the application fails, you can proceed with your trial, and then of course you would always have the right for review and appeal. Now, just in my answer, can you understand how and why am I saying that for paper 3 you need to know law? You need to know, for example, just in the 2 answers that I gave you, you need to know what is the Prescription Act. What does that mean? What are my defenses to prescription, because you need to advise your client, and so civil procedure falls in there. Insofar as the magistrate, of course, you'd need to know, again, civil procedure, even criminal procedure, and your rights to appeal and your rights to review, because that would be part of your answer. All right, you guys are with me. Okay, let's see. I just want to have a look at my notes. Okay, big one. Fees. Okay, let's talk about fees very quickly. So I want to emphasize this point because, again, I love it when it's practical, and I love it when we can actually legit make reference to practice. As an attorney, you are not allowed to share fees with anyone aside from another attorney. So you're not allowed to share fees with an advocate. You're not allowed to share fees with an estate agent. You're not allowed to share fees with any other professional that is seen as touting. So you're not allowed to do that. So if let's say, for example, and I think a common one is a financial advisor, because just in my experience, financial advisors and attorneys sometimes work quite closely together, maybe for wills, administration of deceased estates, that kind of thing. They usually work well together, trusts even. even if a financial advisor refers tons of clients to you, you cannot fee share. So, and what is, let's just talk about what is fee sharing. So you can pay for a service. So if you have someone who's giving a service to you or to your client, you can pay someone for a service. But you cannot, so if it's a referral fee is what I'm referring to. So if, say for example, party A is an estate agent, that's a really good one and a very practical one. Party A is an estate agent, and estate agent Lisa has sold a property. She sold the property, and now of course there's going to be a conveyancing transaction that needs to happen. So Lisa refers this to Aisha Karim attorneys, moi, and Lisa says, well, your conveyancing fee, so my conveyancing fee that I would charge the client would be, 75,000 rand. And Lisa says, well, can we come to an agreement where I'm going to take 25% of that, and then what we'll do in the future is all of my transfers, all of my sales, I'll refer the client through to you. That is illegal. Please don't do that. Don't do that. That's unethical. You could get into serious, that could be considered as misconduct, definitely by the Law Council. Highly improper for an attorney to share fees in that respect with anyone aside from another attorney. So, and to contrast, let me explain this to you. Let's say, for example, I am a family law attorney. I specialize in this area of law, and I have a matter that's happening in Mpumalanga, and that's just a bit too far for me. But I do know a colleague who does also do work in Mpumalanga, and she specializes in family as well. She and I can fee share. So we can do a referral fee and we can do a fee sharing, and that's completely legal. So as an attorney that you guys are about to be admitted, make friends, because you can share money with your colleagues, and you can share fees amongst colleagues, but not with anyone outside of our profession, including counsel. So if, for example, you're dealing with one particular counsel, and let's say you've been referring quite a few matters to them, you absolutely cannot approach counsel and say, listen, can we maybe share your fees? That's improper. You're not allowed to share fees with counsel either. So you share fees with attorneys, and attorneys only, absolutely no one else. All right. So that's the issue on fees. When can an attorney, when can an attorney withdraw their mandate? And this is an important one. Sorry guys, I'm just looking at my notes here. I don't want to forget anything, and then you guys shout me because you failed. Just kidding, you're not going to fail. Okay, withdrawing your mandate. Okay, so here's the thing. When can we as attorneys withdraw our mandate? I want to give my personal opinion here, but I can't, because I want you guys to give the answers that the lecturers are going to mark and be like, this is correct. All right, so there's a few times when you can withdraw your mandate. The one is, of course, conflict of interest. What is conflict of interest? I wonder if you guys know what's conflict of, well, you need to. If you're going to pass this paper, you need to know what's a conflict of interest. So conflict of interest is whereby you have some sort of personal relationship with someone in the case, or perhaps you're dealing with another matter which directly or maybe indirectly impacts your case. So basically, by knowing something or dealing with another matter, it's now creating a bit of prejudice for your client. So let me give you an example. Actually, one of mine, when I just started out in practice, a legit conflict of interest, and how we dealt with it at the time. So I was working for a really wonderful big law firm, and I was, I think, maybe 2 or 3 years into practice, and we were dealing with it was construction, and the construction had gone wrong, and we were representing not the service providers. We were representing the guys who had paid these contractors to erect a particular building, and they just totally messed it up, and they couldn't pass the compliance certificates, and all that couldn't be done. And so we were dealing with these clients. These clients were actually my director's clients at the beginning, and they developed a very close relationship with me, and they asked if I could take over their matter. They really liked working with me. I was very happy to take the client over, and so I did. I think it was maybe about a week or two into the matter that I realized that the company which we were suing was actually owned by a family member of mine. And so I immediately, obviously, I know my family members. I may not know what companies they own. It was after I had gone through some of the documents, and I looked at the directors' names, and I was like, oh no, oh no, oh no. And so I went to my director, and I was honest with him. I said, listen, directors A, B, and C are my cousins, and we do have quite a good relationship. I wouldn't say like inseparable, but definitely, I mean, we chat, we speak on WhatsApp. So this is my family, and I don't know what to do. And so so my director said to me, ask client, what should you do? You need to bring it to client's attention that there's a possible conflict of interest here. And let's just talk about the conflict. Why would there be a conflict of interest here? Because me having a personal relationship with the defendants, of course, could jeopardize my client's case, because I could be giving my client's my cousin's information. I could be sabotaging the case because, you know, I want my cousins to win, or whatever other reasons they are. And it may sound ludicrous right now, and those of us that act professionally and ethically would never consider those things, but this is a legitimate concern, and it's a concern you need to bring to your client's attention. And the client does, of course, have the choice of whether or not you should step down as their attorney or not. In my circumstances, the client did not wish for me to step down. However, I could. That was my choice. I could step down and say that I have a conflict of interest, and obviously I feel very uncomfortable suing my family. So maybe you need to find another attorney or get my directors to deal with it. One of the other reasons you can withdraw, and this may sound a bit far-fetched, but you can actually withdraw when your client has given you illegal or improper instructions. Now, I know for some of you, especially when you're starting out, you'll probably be like, who would do that? Oh, more often than not. And I think the longer you're in the field, the more you see it, and it's sad. And that is one of the times when you can say, I'm sorry, I'm not doing this, and you can withdraw, and you can terminate your mandate, and that's fine. If the client refuses to pay your deposits, as an attorney, you know that you are not required to even pick up your pen without monies in trust. That's why we are who we are, and why we're not counsel, because we are entitled to take our fees up front into our trust account, and then obviously bill our fees against that. So if the client does not pay your deposit, you can terminate your mandate and not proceed. So you could have, let's say for example, you decided to consult with the client signed on at the consultation, signed your mandate, and they were required to perhaps pay a deposit of 50,000 by whatever date it was, and they have not. You can terminate that mandate and say, I can no longer act for you as I'm not in funds to do so. You can also terminate your mandate, and this may sound a bit obvious, but you can terminate your mandate when you have a clash with the client, or some sort of trust has broken down. Now this does happen in practice. You may have a client who suddenly become very hostile for whatever reason, or they're particularly difficult. We, as in the legal profession, we call them red flag clients. They are red flag clients. One of the red flags is the client has had 25 different attorneys on their matter. Amongst us, we say that's a red flag client. And you can terminate your mandate if the clients become difficult. They don't want to take your advice. They're proceeding, or they want you to do things that are not something you're not comfortable with, or perhaps making you go around in circles, or for whatever reason that your personalities are not in line with each other. You can actually terminate your mandate under those circumstances. And of course, if the attorney becomes ill or is unable to fulfill their duties due to any illness or incapacitation, you may withdraw. All right. So, one last thing before I go into really 20 minutes, can you believe it? I want to quickly talk about, while we're on the topic of clients, what kind of fees are considered as. So, let's say that, so the way it's going to be worded in your exams is they're not going to say to you what's considered as reasonable fees. That's too easy. So, they want to give you a scenario. So, they'll say, there was a particular client and they approached the law counsel and complained about the fees that were charged and alleged that the fees were extremely exorbitant. And so the law counsel appointed a liquidator who came into your offices and of course wanted to uplift the file and peruse and see what fees were charged and how and why. And the question would then say what kind of what would be considered when determining whether the fees was reasonable or not. And there's a number of things. So the one is complexity of the matter. So if you're dealing with the particularly, so and by complexity I don't mean, it could be area of law as well, but I mean, I'm a family law specialist, so let's talk about family law. In family law you can have a simple unopposed divorce, which is really not rocket science. Pretty simple and straightforward. It doesn't really require a high level of expertise. It's also quite quick, it's quite simple. The number of documents that you're required to receive from a client is not that much. And so the fees shouldn't be exorbitant. It shouldn't be an excessive amount of fees. However, in the same area, and so we're talking about family law, you may have a matter that's incredibly complex. You may be dealing with, let's use maintenance because those can get a bit complicated. You may be dealing with a maintenance matter. It may even be in maintenance court, but the documents may be so lengthy and so comprehensive. You could be dealing with individuals who have numerous properties, who have trusts and who are beneficiaries on trusts. You may have individuals who are hiding money through other family members. There could be money laundering happening. There's a whole bunch of finances, and then insofar as the applicant goes, and the expenses could be again very lengthy because these are perhaps high profile clients who the children go to private schools and they have a private nanny and private tuition, and they shop at exclusive stores, etc. And so the list of expenses and justifying those expenses for the maintenance application may be incredibly exorbitant, and it may be incredibly complex as well. So there may be various types of maintenance that's required, also not just in terms of wealth, but there could be, for example, a special needs child, and the special needs child needs a particular type of school and a particular type of caregiver. We could have children who it could be as something as I say simple loosely, I don't mean simple. I mean something perhaps a bit more common like ADD or ADHD on the spectrum, and then you could have autism, and autism has a very large spectrum. So on the larger scale, the child may need 24-hour care, and so this can be seen as a very complex. So when I talk about complexity, that's what I mean, that there's a lot, the documents in which you need to peruse, the understanding of the case, the understanding of maintenance in itself, the understanding of how it's calculated and who's entitled to what and where and how much, and what's reasonable and what's unreasonable. And of course, like again I say, when we're dealing with a special needs child, perhaps what's reasonable for the special needs child and the amount that's necessary for the special needs child may not be the same for someone else. The amount of work that's done will obviously also determine whether the fee was reasonable. If you were dealing with a particular matter and there were a lot of applications that went along with that matter, of course the length, how long was it, over a year, was it over 2 years, did the matter go all the way to trial, did you argue it at trial, was there a hearing, were there applications, were there opposed applications, so how much of work was done? Did you just draft the summons and get it issued? That's not, it depends on how complex the summons is, I guess. I mentioned how many documents. So how much of documents did you require to draft or peruse or, go through? That will also help you determine the amount of whether the fees were reasonable or not. Time spent, that's a big one. Because attorneys, we are selling, if you don't know this by now, well, you should. Attorneys, we are selling our time. So how much of time did you as a practitioner spend on this matter. So you were in court, you waited 3 hours for the matter to be heard. The matter was heard, you then, raised certain issues with the court. The matter was then adjourned. You needed to go down to the registrar and get a date, because that's just the procedure. You went down, you got the date, you came back up, and so in total you spent 7 hours at court in one day. And if your hourly rate is 1.5, then, and you can justify how you spent that time and what happened during that day, again, like I said, your time spent, you had 17 consultations. Obviously the bill's gonna be bigger if you've been spending that amount of time on it. And of course, one of the big ones is the seniority of the practitioner. Those of you who might have already completed your studying would know that attorneys charge according to years of experience. So an article clerk is not going to charge the same rate as a senior practitioner with 25 years worth of experience, and also the speciality of the practitioner as well. So you may have a practitioner who specializes in a particular area of law, and that's the reason why their fees are perhaps a bit higher than others with the same amount of years. It's that their area of speciality is the area that you are requesting legal services on. And then just in closing, I'm going to talk about overreaching. So what is overreaching? Overreaching, although I've been shocked many times when I've seen some attorneys' bills, overreaching is when you see an account that is improperly excessive or induces a sense of shock. That's very subjective. I've been very shocked sometimes when I see some bills from my colleagues. So yeah, but that's the answer if you need to write it in your exam. I'm gonna stop there. I think that was almost 30 minutes, and I hope whatever little information I was able to give you really helps. And like I said, my one word of advice when it comes to especially paper 3, please do not deal with it in isolation. Please know all of your papers, please know the laws, please know the procedures, so that you can apply ethics to those particular areas of law. And that's exactly how it's going to happen in practice. You're going to be dealing with your colleagues, you're going to be dealing with clients, you're going to be dealing with the court, you're going to be dealing with the law counsel, you're going to be dealing with clients' trust monies, and in every aspect of your professional life, you need to be dealing with it with an extremely high level and sense of ethics. Okay guys, good luck. I hope you all pass and do really well, and I see lots and lots and lots of new attorneys being sworn in the coming months. And yeah, all the best guys. Take care.